welcome to the sixth episode of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Dr. Juliette McIntyre, lecturer in law at the University of South Australia. And tonight we are turning the tables on Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra. It's time to put our esteemed host in the hot seat. Douglas, good evening. First question, what's your drink?
Well, good evening, Juliette, and thank you for hosting this episode. The cocktail hour approaches in Canberra, but I am still at the office and failed to preposition anything. So I am continuing to work my way through a box of South Korean teas, and this evening's is green tea, which tastes, I don't know what to say, it tastes exactly green tea-like.
Delightful, delightful.
And Juliette, what's your drink?
Well, I am also in the office, but I happen to have a lovely bottle of an organic biodynamic Montepulciano sitting around. So I've actually cracked that and have gotten a head start on the Friday night festivities after a rather challenging week. But it tastes rather nice, actually. It's quite good.
Excellent. No, I should perhaps preposition something in my office for just such an emergency myself.
Now, look, we usually begin each of these shows with a little bit of background on our friendships and career paths. And obviously, I talked a little bit about our friendship during the first episode. I'd love if you could tell our listeners, though, a little bit about how it was that you got into international law and the career path that has brought you to your current job.
Okay. Well, let me start with how I got into international law. So I was not a particularly gifted law student in my first couple of years at uni. In fact, if I'd been assessed for a job based only on my marks in property, tort, and contract, I wouldn't have gotten very far in law at all. But the things I really did love at high school and university level were debating and drama. So eventually I got into mooting, mock courts. And it was when I started having to do that mock advocacy and make arguments out of the law, I suddenly began to understand the law. Also, it turned out I was pretty good at it. And so I ran through all the mooting competitions I could find, and the last one left was the Jessup Moot. And in my undergraduate arrogance, I went, well, I haven't done public international law, but with a lot of these moots, I hadn't done the compulsory subject. And if I had, I found it only saved me about a week of research. And after that, I was down on something very specific. I would just do the research. So I joined the ANU Jessup Moot team. Like Imogen Saunders' team some years later, we went all the way to the international grand final in Washington, D.C., where we were runners-up. Unlike Imogen, we didn't win. But I was very fortunate to get the Best Speaker in the grand final award before a bench that consisted of James Crawford, Rosalind Higgins, and Pia McAvan.
Oh my God.
I know, it was a pretty defining kind of a moment, having those people tell you, yeah, we think you can do international law. So I thought I might, in fact, have a future in this subject. But then when it comes to the actual career path bit, I thought what I would do here is because everyone has spoken, I think, with real sensitivity and value about their career paths on the pod so far. We've had people like you who are effectively first in family to go to university, non-traditional backgrounds, people who enter this field, international law, where there's this perhaps expectation that you should study abroad, but have only ever studied in Australia, and people who've made a career in international law as very much as immigrants to other countries or systems. So I'm the middle-aged white guy in the pod, right? So my question was, well, what value add can I add here? And I thought I'd just kind of contrast what I'd call the website or CV version of my career with what it actually felt like. So if you look at the kind of career summary I've got on my website, it looks pretty standard, right? Went to good Australian law school, got a job with a major city law firm in Sydney, worked for a couple of judges of the Federal Court of Australia, graduate study, master's, then PhD at Cambridge, first job at University College London, returned to Australia, went to Monash University, one of our so-called group of eights, a very big law school, the second major law school historically of Melbourne, and then came to the campus, the Canberra campus of the University of New South Wales, into this wonderful small team at the School of Humanities and Social Sciences, all of which looks like this sort of smooth career path through institutions where I gradually do more and more security-focused stuff and eventually move out of law schools into essentially an international and political studies program. That was not the experience, right? I was miserably unhappy in my first job as a corporate lawyer, and in retrospect, probably a little bit depressed. And I started looking for jobs with judges to get out of that. The first judge who hired me, I'd never actually got to start with him because he medically retired from the bench early. And then, I essentially sort of got picked up again later. I got this call back from a judge who was essentially hired to replace him, who needed an associate on short notice, and decided not to interview, but just to get someone who could get him started for 6 months, right? Then my whole trajectory in terms of international study was essentially came about because the woman I was dating at the time, the love of my life, dumped me. And I went, oh, well, I'm single now. I might, if I'm a free agent, I might think about applying for international study. That woman later married me, right? So it worked out okay in the long run. But had we settled down in Melbourne, I don't think I would have done that necessarily. Then, the move back to Australia was around family circumstances. We had a young child and had to decide whether we were going to raise him in the UK or Australia. And then Monash, look, I loved the people I worked alongside, but it was not the right institution for me. And it was definitely becoming sort of bad for my mental health. I wanted to move back to Canberra, but the first job I applied for at the ANU, I didn't get. And then they eventually didn't fill that role. And I effectively took a demotion to come to UNSW Canberra, out and leaving a law school, which is a big psychological step for me. And in a sense, I felt this was doing something really risky, but I was doing it for family reasons and to get out of, again, a job that was not for me. And the results have been great. I've actually really loved the role here. I've loved having a more interdisciplinary perspective on what I do. And I feel I've landed in a sort of very lucky and happy place. And being able to bring that more interdisciplinary perspective to my work enabled me to put together the project proposal that's my present research fellowship. So all of these things, in a sense, I think we've said this in an earlier podcast, careers make sense in retrospect. You look backwards and you can see the steps that led you to here. But at the time, it's often just chaos. And I think your piece of advice from an earlier episode, sometimes you don't get to make the next, like the decision that seems to be the next step up a particular ladder of prestige or a particular career path. You have to take the best of what's available. And sometimes that opens up things that you wouldn't actually have thought of.
Yeah, exactly. And sometimes they can be really good choices actually in the long run, but especially if they are contributing to, improved mental health or improved general happiness or, making family situations work. Like these are all the things that people have to juggle in their careers. And it's hard to balance those things, I find. Or I mean, maybe that's just me. I can't juggle, but these are, you're a person, you're not just an academic, so when we look at our website version of our careers, it's just our academic achievements and the things that we've done. But, you're a whole person, and those other parts of your life are equally as important.
But often what we see when we look at each other as academics is the website or CV version, and you don't see the full person behind that. And I do think that's imposter syndrome is an overused term, right? But it's a contributor to that feeling that, oh, everyone else is so much more glamorous, successful, accomplished, does it all so much more easily than me. The older I get and the longer I've been in sort of university leadership positions, the more I realize that actually, a lot of people are carrying a lot of stuff in their lives. And sometimes work is the place people come to because it's contained. They get to be a professional. They get to put on their professional face. They get to do things in a controlled environment that makes sense. And when very often the rest of the world doesn't. And it's not a bad thing that people get to project that, but you can kind of forget that, everyone else has got a hinterland, things going on beyond the person you see.
Yeah, definitely. I was thinking about this the other day in respect of social media. Like we assume we know someone from what they post on social media, but then you think about yourself and you think, well, what do I put on social media? Does that reflect all of me? It really doesn't. And it's the same thing with your CV. It doesn't reflect everything that I've ever gone through. It's just a snippet. It's like a best version of myself. And I want to shout out to Fleur Johns, actually, because she was a huge inspiration to me because on her, I don't know if she still has this, but on her website CV at one point, she had written that she had worked part-time and that she was raising children and that she'd done these things. And I was like, that was the first time I'd ever seen someone put that on their actual CV. And I was like gobsmacked. And I thought that was amazing. And it was so inspirational to me to go, actually, yeah, you can be honest about these things, these other parts of your life as well. They don't necessarily have to hold you back from achievement.
Right, right. And with great nervousness, I wrote a piece some years ago, I think at the tail end of the pandemic, on mental health in academia, commissioned as part of a blog series on life in academia. And I can put it into the show notes later on. But that was, for me, part of kind of going, well, we are all people. We all struggle sometimes. And in one of those periods, I did have to go part-time for a while to get back on track.
And look, this kind of is a segue for me into something that I think you're a little bit famous for this, is some blog posts that you wrote back in like 2012 on Eagle Talk about how to do a PhD in international law. And I think they're one of the most popular posts on Eagle Talk like ever. People, type how to do a PhD in international law and that's what pops up. And I wonder, since you wrote those, has any of your advice changed? Would you say different things to prospective PhD students now with the added benefit of a little bit more hindsight and reflection?
Yeah, look, I think I would, and I think one of the virtues of middle age is you take a kind of wider perspective on things and are occasionally slightly embarrassed by younger versions of yourself. I don't think it was express in those posts, but I think there was a sort of subtext of there's a best way to do a PhD, and then everything else is potentially a bit of a struggle. I think most of the advice stands up, but I think there was a subtext of if you can't do it, full time and fully funded, it's going to be a tough road. And certainly it's going to be tougher, right? But I don't think I held enough space in those pieces for the part-time or the non-traditional career path experience of doing a PhD. And I'd hate anyone in retrospect to kind of read them prescriptively and feel that they couldn't do a PhD if they couldn't do it in the ideal way. What I was trying to do in my own mind was frame the risks. But in retrospect, I think I was a bit entrenched in, there's a best way to do it and there's everything else. The other thing I think I would add to them, which is not kind of strictly relevant in a sense to the process of doing a PhD, which is what I tried to focus on in those, but it's more about the development of your career, both through a PhD and either post-PhD as someone with a PhD working in another sector or as an early career research academic. And that's the importance of horizontal network. I think a lot of people come through a PhD program into an early career researcher phase really thinking that they need to make what I'd call vertical connections, that the contacts that you build that are really important are with the very senior people in your field. And those are the ones who are going to put opportunities your way or open doors. And to some extent that is true. And having a supportive, for example, PhD supervisor is a huge asset. But as you get further into your career, I've always found that the networks that sustain you are the horizontal networks, the networks of your peers that you establish along the way. And I think some people don't pay enough attention to their horizontal networks or are, occasionally, awfully, quite scornful of their peers and only kind of face up. And not most, but many of the really important opportunities that have come to me have been because people at the same career stage have said, for example, I can't do this, but is it what you're looking for?
Yeah.
Or have you heard about this opportunity? Or if I need someone to give me a quick reaction on a promotion application, whether I might be a fit for a job, first read of a sort of sketch for a journal article, the people who are going to do that are my peers. It's not people several steps above me.
Yeah.
And also, as we were discussing before we started recording, you reach a stage in your career where the great and the good, or the people you regarded as the great and the good, start to retire or even sadly pass away.
Yeah.
Right. And then you are just alone with your peers and your juniors.
No, that's exactly right. And there's a huge benefit to having people around you who understand what you're going through at that moment, because, time tends to fade the memories a little bit. And as well-meaning and brilliant as your senior mentors might well be, they're not living through that moment of, for example, book proposals. That's something I've just done, is trying to write a book proposal. And it was my peers, for the most part, who I was able to reach out to and say, hey, I noticed that you just did this recently. Could you help me out here? Seniors could give great advice on general sorts of topics and general approaches. But, it was the horizontal networks that were the ones who were really able to sort of sit there with me, provide tangible support, let me cry, whatever it was that might be needed in that moment. And then I can give that support back to them in turn. So yeah, I completely endorse that. Now, look, I'd love to continue this, but I think we should move on to our main topic this evening, because it's quite a juicy one. There's been a lot of footage on social media over the last year or so of clashes between the coast guards of China and the Philippines in the South China Sea. And in much of this footage, the Chinese Coast Guard vessels seem, well, warship-sized, frankly, and they completely dwarf the Philippines' craft. We've seen incidents like the Chinese using water cannons that are shattering the windshields of a Philippines Coast Guard vessel. And then this week, or last week, 17th of June, I think it was, there was this standoff near the Second Thomas Shoal. So these two groups of small craft faced off against each other. And there was footage of a Chinese Coast Guard individual, brandishing weapons and pointed tools and, sort of seeming to threaten to puncture the Philippines Coast Guard's boats. And one Filipino Navy officer lost a thumb in all of this violence. So it's gotten kind of extreme. And I know I have quite a few Filipino friends on social media, and I've seen a huge uptake in posts about this incident on their social media. It's being taken really seriously. So I know this is your wheelhouse, and I'd love to know what is going on here from a legal point of view, and how, if at all, does this relate back to the South China Sea arbitration that took place in 2016?
I think one of the impressive things here is the social media campaign and information campaign that the Philippines has been running around these incidents. And we can come back to that. And we can also come back to the consequences of the 2016 South China Sea arbitration, or the framing that puts around these incidents. Just to begin to untangle the facts, I guess. So both the Philippines and China claim jurisdiction over features and waters in the Spratly Islands, which is a misleading term, right? This is a large area of the South China Sea with lots of, let's call them maritime features for the moment, very few of which are islands in any sense. So, for example, the Second Thomas Shoal, where we've been seeing these particularly intense incidents, is a submerged reef or atoll surrounding a lagoon. It's about 20 kilometers long. And like a lot of these deep sea reefs, it provides an important fishing ground for Filipino fishermen. You get these reefs in the middle of the sea, and fish tend to concentrate around them. Now, it's also only about 13 nautical miles from a Chinese base on the aptly named Mischief Reef, where the Chinese military engaged in a whole lot of sand dredging, dumped sand on top of a live coral reef, killing it, and built a little military outpost on it. Now let's come back to the fishermen. So if you want to assert jurisdiction over fishing, you send Coast Guard vessels out to patrol. But doing fisheries law enforcement is also an assertion of sovereignty, right? So it's a way of claiming jurisdiction over an area, demonstrating your claim of jurisdiction. And using Coast Guards, the advantage there is that it's rather less aggressive and escalatory to send a white-painted Coast Guard vessel than a grey-hulled warship, even if, in fact, there may be a very limited difference between the two. The Coast Guard vessels aren't necessarily packing the kind of weaponry that a full-on frigate would, but they're often, as you say, of a frigate scale and often still pretty well armed. The Second Thomas Shoal falls within the infamous 9-dash line area of the South China Sea, within which China claims jurisdiction and proclaims an annual fishing moratorium that runs from May to September. So as a general conservation measure, that's not necessarily a bad thing. The South China Sea is enormously overfished. But China's controversial Coast Guard law of 2021 permits the use of force and the forceful towing of vessels where foreign organizations and individuals have infringed on China's sovereign rights and jurisdiction at sea. And that includes sovereign immune foreign government vessels. And it asserts these powers throughout, quote unquote, maritime areas under China's jurisdiction. Mm-hmm. Now, all of this embodies a lot of ambiguity, which has been China's legal strategy regarding the South China Sea, because this phrase maritime areas under China's jurisdiction isn't obviously linked to terms such as exclusive economic zone you would find in UNCLOS. So the basis of the jurisdiction is unclear. Then on top of that, from just before this incident, from 15 June 2024, they issued regulations that says that the China Coast Guard can detain foreign vessels and persons in waters under China's jurisdiction for up to 60 days. So you've got two elements of controversy here. One is, well, three. One is, does China have any valid claim to jurisdiction in these waters? We can come back to that. The short answer is no. Second, they've passed these broad and ambiguously worded laws, which on their face apply to foreign government vessels as well, and which potentially contemplate the use of force. So from the Philippines' point of view, it obviously wants to protect its fishermen from what it sees as harassment, but also to assert its own claims of sovereignty over what are its waters. Now, but why you get this intensity around the Second Thomas Shoal, one, the flashpoint is this thing about fisheries jurisdiction. Who owns the waters? We're both patrolling it to say we own the waters. Yep. The other one is, and I don't know if you've heard of this, the Sierra Madre. So this is a rusted out Philippines naval vessel that was deliberately run aground on the Second Thomas Shoal in 1997 or 1999. And now every month there's kind of a fight in the water in front of it.
Oh, okay. Like, why? I mean, why did that? Okay, so two questions. Why did they do that? I mean, people sink vessels to create reefs and things, but what was the point of this?
Right. So it wasn't sunk, it was run aground. So it's on top of the reef and protruding out.
Oh.
And what it does is it provides a platform for a continuous military presence to assert Philippines' sovereignty and jurisdiction. Now, that continuous military presence is, as far as I can work out, a handful. Like, we're not talking a garrison. We're talking a couple of guys basically camping on the deck of this rusting ship.
Oh my God.
And you can look up photos online. They're essentially sort of living under sheets of corrugated iron and doing campsite cooking.
Wow.
On this exposed thing in the middle of the ocean. So the conditions on board do not look great, and you need external food and supplies to stay there. So there's been this monthly standoff when the resupply boat comes in. Now, the other thing is you can't just pull up a full-size Coast Guard vessel along it, right? You have to kind of break the supplies out into what are called rigid-hulled inflatable boats, or RHIBs, ribs, to run it over. And that's the point where the China Coast Guard also drops its ribs into the water, and you have these clashes. So the specific reason is, according to the website The Diplomat, or articles on it, Chinese officials have accused the Philippines supply ships of bringing construction materials in to reinforce this slowly decaying, rusted out ship, which is apparently in violation of some agreement or verbal assurance given by the former president of the Philippines, Rodrigo Duterte, that only basic supplies would go on board. So in these recent clashes, you've seen the Chinese Coast Guard actually taking off Philippines personnel, things like food, fuel, M4 rifles, and navigational equipment. Yeah, intense, right?
I just feel really sorry for these guys who are stuck on this like rusted ship in the middle of the sea, just to sort of uphold this Filipino claim to this area. But I guess if they were to abandon that ship or to just stop kind of fighting back, then China's claim would become effective, wouldn't it? That's really the point here, is that they're...
Well, I guess this brings us over to the... this brings us over to the question of what the 2016 arbitral award had to say about all of these questions.
Yeah.
So essentially, what the Philippines did in that case was to challenge the 9-dash line, the validity of China's 9-dash line under what are called the Part 15 Dispute Settlement Procedures of the UN Convention on the Law of the Sea, or UNCLOS. And if you look at a map, one of the reasons you would want to do this if you're the Philippines is one of the dashes on the 9-dash line comes to within 50 nautical miles or less of the Philippines coastline. And if you think you're entitled to a 200 nautical mile exclusive economic zone where you get to control fishing, for example, that looks like someone who's trying to take a pretty big chunk out of your maritime zones. However, the status of the 9-dash line could only really be challenged collaterally. So what I mean by that is one of the ways China was perhaps making the claim, there are a number of things it was claiming. One, that it had strange special historical rights because of the ancient Chinese use of these waters. Now, there were two problems with that claim. One is all the other states or proto-states or communities that surround the South China Sea also made ancient historical use of these waters, right? But China was only interested in the use that sort of proto-Chinese states had made. And second, the arbitral tribunal eventually said, look, this historic borders claim has no space. This historic rights claim has no space under UNCLOS. UNCLOS does have a special provision on what are called historic waters, but these are like special rules that apply to a section of your territorial sea where they get to be treated like internal waters if everyone has always agreed that's the way they should be treated. So you get strange, narrow passages of water in Scandinavia and whatever, where that sort of rule might apply. So the more plausible claim for the 9-dash line was what we'd call in Australia kind of an ambit claim or a maximalist claim, saying everything within these lines we own. And if it's an island, it projects a 200 nautical mile zone for us. And if that carves all the way into 50 nautical miles out from your shore, tough luck you, or maybe we can have a delimitation dispute about where that should be. But all of that presumes that the question is who is sovereign over these islands that project 200 nautical mile zones. What the Philippines did was really clever. Instead of challenging ownership of the islands, which you can't strictly do under Part 15 of the UN Convention on the Law of the Sea, it said what we want to debate is the status of these maritime features. Now, this is where I have to get down into the technicalities. So if you read Article 121 of the UN Convention on the Law of the Sea, it distinguishes two things expressly and kind of a third thing implicitly. So it says there are islands, which are bodies of land above water at high tide. So there's always part of them sticking out of the sea.
Yeah.
And they can generate a territorial sea, a contiguous zone, and an exclusive economic zone. So that's a very...
full 200, as it were.
Yeah, the full 200.
Yeah.
So these are very valuable pieces of real estate. And it's resulted in things like Pacific Island states having these vast maritime territories and very small physical or land territories, right? Because they get these 200 nautical mile zones around all of their individual islands. But the converse of that is a rock, which is above water at high tide, but incapable of sustaining human habitation or economic life of their own. So implicitly, that tells us that islands must be capable of sustaining human habitation or an economic life. But all rocks get is a little 12 nautical mile territorial sea. Then by implication, we have this residual category, which we call in the jargon low tide elevations, or LTEs. The idea being that it's only elevated, there's only something you can see above water at low tide. So a lot of the time it's covered by water, but it might occasionally stick out. Right. And low tide elevations generate no zones. So to sum up, islands are very valuable, and a state can have sovereignty over an island that's very close to another state, or that might even be within its EEZ. We've seen lots of ICJ maritime boundary delimitation cases where that sort of thing has happened, particularly off South America. But here was the thing that was great for the Philippines. The arbitral tribunal held that none of the disputed features were islands, most weren't even rocks, and features such as the Second Thomas Shoal and Mischief Reef were at best low tide elevations. Okay. So the consequence of that is China has no claim to features that could project Chinese exclusive economic zones towards the Philippines. Therefore, the Philippines must have the full 200 nautical mile EEZ, and therefore the Second Thomas Shoal and Mischief Reef fall within it.
Right.
So they just belong to the Philippines. They're just features within the EEZ, which means...
So why the boat then?
Well, so China has obviously not accepted that result, because if you did accept that result, amongst other things, one, if that result obtains against the Philippines, it obtains against every other corner of the 9-dash line, right? And other states, particularly Vietnam, have started pushing back and going, no, the 9-dash line has no status in international law. We're entitled to a full 200 nautical mile EEZ. So you can't, from a Chinese point of view, you can't let that claim go. And if you believe that you have sovereignty in these waters, or that these features are somehow magically archipelagos capable of generating zones, you have to act on that basis, right? And particularly once you've been acting on that basis for a while, if you suddenly stop doing it, it looks like a concession.
Yeah. So this is so okay. This is so interesting to me. I'm going like fully off script here. This is very fascinating. So it's not, so this what is the boat then? Like the boat is a LTE? Is that how this works?
No, well, technically the boat is an artificial island.
Yeah, right.
So it's like an oil platform.
Okay.
So you could, under the law of the sea, you could claim a zone around it, but not a territorial sea. Artificial islands only get a safety zone of a couple of 100 meters.
Okay.
So similarly, when the Chinese dumped a whole bunch of sand on top of Mischief Reef and created an island, that doesn't magically generate a Chinese territorial sea and exclusive economic zone. Again, all you can claim in the case of an artificial island is a safety zone of a few 100 meters.
Gotcha. Okay. All right. Starting to come together for me. So look, some commentators on Twitter have suggested that what took place the other week, with the poor Filipino naval officer losing a thumb and all of this, looks like an armed attack by Chinese forces on Philippines forces. Could this, there's obviously been a lot of tension and a lot of argumentation, a lot of argy-bargy, but could this escalate into something really serious? And does this have implications for the United States and their mutual defense treaty with the Philippines? Like how big could this get?
Well, I guess there's the wider political question, which we may or may not be qualified to answer. And then there's the legal question, which you and I might be qualified to answer. So certainly the president of the Philippines has said that these incidents are very, very serious. And if a Philippines serviceman was killed, they would regard that as something close to an act of war.
Yeah,
so
wow.
That's at the political level.
Yeah.
Now, I do think China's conduct has been informed by thresholds set in international law. So China is often accused of using what are called grey zone tactics, which is, if international law makes a response lawful at this level, he said, usefully making visual hand gestures on a podcast.
His hands are approximately 3 inches apart. Let's just
right. Then you can come up to just below that level and be quite provocative, but try and, as it were, keep below the legal red lines that might trigger escalation.
Yes.
So the idea is that you're constantly doing things that are assertive, that in your mind assert your rights, and you're pushing up towards that level, but trying never to cross it, which again is why, for example, you use Coast Guard vessels, not warships. Coast Guard vessels are an assertion of sovereignty, but they're seen politically as less escalatory than a warship. So
yes.
the relevant threshold here, I guess, is the idea of, at what point do you cross the level of an armed attack giving rise to a right of self-defense? So Tamsin and I touched on these points to some extent in episode 5. But obviously, as general international lawyers, we know that a state has a right of self-defense if an armed attack occurs. And when we look at these incidents, the layperson will go, but these guys have got, machetes or axes or whatever. How is that not an armed attack? In a common sense way, that seems to be an armed attack.
Yeah.
However, as we know from the Nicaragua versus the USA case of 1986, armed attacks must be of kind of scale and effect such that they are not, and the language in, I think it's paragraph 192 or 196, is, more than a mere frontier incident.
Yes.
And so when we think of frontier incidents, we can think of incidents in which people are even killed, right? We can think of standoffs on the North Korea-South Korea border, where someone might take a pot shot at someone else, or those appalling scenes that occasionally crop up on the border between India and China.
Mm-hmm.
And this sort of incident looks a lot more like a quote-unquote mere frontier incident than an armed attack.
Yeah.
Particularly because there seems to have been a very conscious decision not to use firearms, right?
Yes. Yeah. Well, that's the thing, right? Like we've got machetes and sharp tools, but no guns, right? Which is a sort of a deliberate...
And I think you could actually use a gun and it still be a mere frontier incident. But to me, that seems to be a very deliberate bit of signalling. So
Yes.
if you haven't risen to a level of force that would constitute an armed attack, no right of self-defense, in theory, no legal red line crossed that would justify escalation to something on the scale of war. The interesting thing, though, is, as you pointed out, the US-Philippines Mutual Defense Treaty, because while that again hinges on the idea of ideas like armed attack or threats to the sovereignty, territorial integrity, or political independence of either party, the United States' official position has always been that any use of force whatever could justify a response in self-defense.
Mm.
So the US doesn't acknowledge that there's some threshold below which you don't get a right of self-defense.
But that's very generous too, in the sense that it basically allows them the opportunity to decide when it is that they want to get involved.
Exactly.
Yeah.
And that's the other thing about the US-Philippines Mutual Defense Treaty is it's a lot more like the Australia-US Defense Treaty than it is like the North Atlantic Treaty Organization, the NATO Self-Defense Treaty. So NATO Article 5 famously says an attack on one is an attack on all. We must come to the aid of another member of the treaty if they suffer an armed attack giving rise to right of self-defense. What the US-Philippines Treaty talks about is consultation.
Mm-hmm.
So that the parties must consult whenever either party thinks it's been attacked in the relevant hemisphere or Pacific. So that means the Philippines can invoke the treaty and, as it were, call for US aid, but there's not an automatic right to give it. But nonetheless, the US has sent some pretty strong political signals saying they regard the treaty as potentially, one, in force, and two, having application in these waters. So they've sent a signal to China, not necessarily that they regard these incidents as having triggered the treaty, but they say, it is applicable in these waters, and effectively we're watching these incidents.
Yes, yeah. So to take your hands moving from 3 inches up towards 1 inch, they're sort of saying, look, we can see that you're very, very close here, but we're not quite over the threshold yet. So look, just going back to the legal question, though, we talked about the South China Sea arbitration, and this was heralded as this enormous decision, but doesn't all of this kind of show that the award wasn't super useful? China, I'm a court person, I hate to say that, but China hasn't backed off. Philippines is still engaged in the dispute. Like, what was the point of that decision if it hasn't stopped China from doing what it's doing?
So, and I mean, this is a question for both of us, right? And it's one I've been engaging in with my legal statecraft project. But, what's the point of going to court if you don't expect compliance? And the thing is, I don't think small states, when they go to international courts or tribunals, magically expect that there will be compliance, right? You'd have to presume that they were fairly naive to do that. So if that's the case, if we presume that small states and their lawyers aren't stupid, then what is the point of going to international courts and tribunals? And so summarizing a whole lot of my own work into kind of 2 bullet points, I think there are 2 things that international litigation and a successful outcome before an international court or tribunal are really good for. One is an adverse finding against the respondent state, here China, tends to delegitimize their position in international politics. So you get to put a thumb on the scale of international politics, and it's harder for others to say, oh, well, he said, she said, whatever's going on here is between you guys, when you can say, no, this is an actual breach of international law.
Yeah.
Secondly, what legal argument and legal argument before courts gives you a platform to do is say, not that this is merely a bilateral dispute, China is infringing on our individual interests as the Philippines. You can start saying things like, this is an attack on a right that is enjoyed by all states
Yeah.
or by a large group of states, like every state with a coastline. If the UNCLOS guarantee of the exclusive economic zone is worthless, that has implications for states other than us. So you can use the case to draw support to your cause by saying, look, guys, you're in the same boat, and this is not just a question of our interests. There is genuinely a multilateral or international interest involved here. And we have seen some of that with the South China Sea Award. Like, it's been invoked by a number of states contesting things before UN bodies, particularly Vietnam has referred to it on a number of occasions. And I think one of the things it does, in a sense, is we often look to international dispute resolution to end a dispute.
Mm-hmm.
But sometimes, if you can't, because the other side won't back down, freezing a dispute in place isn't necessarily a bad outcome. And essentially saying, no, we're not going to back down. We don't have to back down. And this is a question of our legal entitlements, actually kind of gives you a position of at least symbolic, if not material strength, to try and maintain your position. And there's been talk of whether the Philippines would go back and launch a second case against China, saying China hasn't complied. Now, again, the expectation there wouldn't be magical compliance. It would be putting pressure on China. Yeah. Now, while things have escalated a lot this year, there were signs in 2023 that the Philippines information operation, essentially going, we are going to name and shame what China is doing as breaches of international law, had resulted in the China Coast Guard being a bit more circumspect. But things appear to have ramped up again now. So, as I say to students, international law can't solve the problems of politics, but it can definitely put a thumb on the scale for small and medium-sized powers.
Yeah. And you mentioned earlier at the start as well, the use of social media and popularization of the cause that the Philippines government has been using as well. And I guess it's beneficial in that respect too, for a domestic audience to say, these are our legal rights, and the tribunal has confirmed them, and it creates this really strong narrative that the government can then use for its own benefit.
Well, and what's really interesting is actually the extent to which the concept of the exclusive economic zone has passed into popular consciousness in countries like the Philippines and Vietnam. Like the EEZ is an artifact of law. It has no physical embodiment. There aren't magical lines in the biome where certain fish start to exist or stop existing at 200 nautical miles or whatever.
This bioluminescent sort of thread that you can see from space. Yeah, exactly.
It is, it's just a legal idea. But the moment you tell people they own something, that can become internalized really rapidly. And while China has embarked on this big campaign of maritime nationalism, telling its own nationals, we own everything in the 9-dash line, I think they've underestimated the extent of maritime nationalism in other countries. So when China has sent oil rigs exploring inside what should obviously be the Vietnamese EEZ, sorry, not oil rigs, what are called mobile offshore drilling units or exploratory vessels.
Right.
There have on occasion been anti-Chinese riots in Vietnam that resulted in the Chinese Navy having to evacuate nationals.
Wow.
That's the strength of feeling about Chinese incursion into our waters. So there's a clause in the Philippines Constitution that reserves the benefits of the exclusive economic zone for the people of the Philippines, which has also made it politically harder to cut joint development deals with China. So there's this sort of element to which law and popular consciousness aren't, or ideas of nationalism aren't completely separate. They're kind of mutually implicated. Yeah. Well, now, Juliette, time is always against us. And I had a question for you about international court proceedings. So obviously in this pod, we're keeping an eye on various proceedings concerning Gaza before the International Criminal Court and the International Court of Justice. And as our resident procedure goblin, I wanted your take on Palestine's recent efforts to intervene, correct my language, in the South Africa-Israel case before the ICJ.
Yes. Oh, I'm so glad you asked, because this is so interesting from a super nerdy proceduralist point of view. But it's also, I guess, I hate the word layperson, but from that layperson point of view, it seems kind of obvious, right? Like, this case is clearly about what's going on in Palestine. So surely Palestine should be involved in some respect. So What's happened is that the state of Palestine has done two things. It has, first off, submitted to the court a declaration recognising the competence of the court, because, of course, Palestine is not recognised at the UN, therefore it cannot be a member of the UN Charter. It cannot be have all the rights there under, and therefore obviously is not a party to the ICJ statute either. So first off, it's got to do this little funny thing where it says, okay, we recognise the competence of the ICJ in respect of various disputes, including those in respect of the Genocide Convention. So it did that. And then that's enabled it to use the mechanisms under Article 62 and Article 63 of the ICJ statute that allow a state to intervene. Why is this interesting? Well, we haven't seen since the 1920s a state try to use both intervention mechanisms. And in fact, in the 1920s, for the PCIJ, what happened was that Poland intervened in the Wimbledon case using Article 62. It was then pointed out to them that actually that probably wasn't the best mechanism and they ought to use Article 63, and they changed their mind and used Article 63. So this is really, really unusual, because here Palestine is full on 100% trying to intervene using both mechanisms and has a great case, actually. Let's explain very quickly. Article 63, everyone is familiar with nowadays, right? Because everyone is intervening using Article 63. If you are a party to a multilateral treaty that is being interpreted by the court, you have a right of intervention to submit your views on how that treaty ought to be interpreted. Pretty much everyone has used that mechanism. Ukraine case, Myanmar case, this case, the South Africa-Israel case.
Well, any case brought under the Genocide Convention, right, is going to have that possibility. Okay,
that's right.
Because it's one of the most widely ratified treaties, and the reason these cases are brought under the Genocide Convention and not under other instruments, as we said before, is the Genocide Convention does have a really useful dispute resolution clause that allows the ICJ to weigh in, whereas if you wanted to argue war crimes, there's no equivalent in the Geneva Conventions.
Exactly. So, I mean, this is very straightforward and everyone's getting in on it. Palestine is no different in that respect. What's interesting is this Article 62 intervention, because Article 62 requires that the state has a legal interest in the question that the court is deciding. Now, look, for Palestine, honestly, they spent a few pages on submitting why they had a legal interest in this case, but really you could have written one sentence. It's obvious that a case which is deciding whether or not genocide is taking place in Palestine, involving the Palestinian people, that clearly implicates the rights and interests of Palestine itself. One thing I did find really interesting, though, in the submission from Palestine was that they didn't lead with that argument. What they led with was the argument that all states have an interest in this case, or in any case brought on the basis of an erga omnes partes obligation, due to the phrasing of the court in the Barcelona Traction case, which says all states have an interest in the interpretation application of erga omnes obligations. Now, this is going to be very interesting for two reasons. One, the court is going to have to actually, for the first time ever, decide what it really means by legal interest in a case. Is it the same thing as a legal interest that gives you standing to bring a case, or is it different? In my view, it's different, and it's a little bit controversial, but what the court has said in previous cases is that for intervention, you need not just a legal interest, but a legal interest that requires protection. So there's like this little extra layer that is required for intervention. I don't think that's the same as for standing, where you can choose to bring the case. Point one. Point two is the reason this is interesting is that we've got Nicaragua, who's also tried to intervene in this case on the basis of Article 62. What the heck has Nicaragua got to do with this case? What is Nicaragua's legal interest? It has none. It has no legal interest, none whatsoever, except for the same arguable legal interest that every other state in the world has in the enforcement and upholding of legal obligations, erga omnes. In a way, there's not a lot more to say right now. Those are like the issues that the court is going to have to grapple with. Obviously, procedure goblins around the world are watching this closely and are very excited by the court's decision that is going to be inevitable eventually here. what are we going to see? We could see Palestine being admitted on the basis of Article 62 alone. We could see them being admitted on the basis of Article 62 and Article 63. There's nothing in the statute that says they can't do that. We could see Nicaragua being admitted on the basis of this argument that all states have Article 62 type obligations, or we could see Nicaragua being chucked out, but Palestine admitted because of the clear factual difference between their two legal interests in this case. So super interesting. Obviously, one to flag for down the track. I don't know how quickly the court is going to get to this issue. It's probably going to be 6 months or more. I think they're going to wait and see who else wants to intervene. But yes,
also it's going to have the interesting effect that the ICJ is going to have to effectively, even if only tacitly, rule that for the purposes of the ICJ, Palestine is a state.
Oh my God, yes. So, I mean, it's only tacit though, right? Because they don't have to answer that question. It's not directly implicated in the phrasing of any of these intervention.
They might if Israel puts an argument to the court that the intervention can't be heard because Palestine isn't a state.
Yes, well, in that case, absolutely, they would have to. But as long as you're a party to the applicable underlying treaty for Article 63, you have this right, and that right extends.
Well, and that might be the way around it, in the sense that the International Criminal Court, as we've talked previously about Palestinian statehood, particularly in episode 3 with Dina, the International Criminal Court didn't say that it concluded Palestine was a state as a matter of general international law. It just concluded that Palestine was a state for the purposes of the Rome Statute of the International Criminal Court, because that was the only thing it had competence to rule upon.
Yes.
And as far as it was concerned, the other state parties to the Rome Statute had treated Palestine as if it were a state, so it couldn't come to any other conclusion. I grossly oversimplify, but that was the gist of it. So in a different way, the ICJ may have an option of kind of saying, well, what we need to do is come to a conclusion for the purposes of the statute rather than the purposes of general international law, or not even the purpose of the statute, the purpose of the underlying treaty which Palestine is invoking.
Yes, exactly. And Palestine is a party to the underlying treaty, and if you're a party to the underlying treaty, you have these rights, and so they can kind of avoid the whole question. But also Palestine is a state. Oh my God, can we stop having this conversation? Not you and me directly, but in general terms. Like, it is so 2001 to be having this conversation. It's so outdated. Like, I can't. There are a few. Alonso Gomendi on Twitter posted that there are. It was something to do with Taylor Swift songs. Like, there's like fewer states, that haven't recognised Palestine as a state than there are Taylor Swift songs that reached #1, or some ridiculous statistic. I can't remember, or Britney Spears, I can't remember.
Right.
But it's just such a bizarre conversation to actually be having, when the facts sort of so in your face. I had
my 10-minute rant on this in episode 3, which listeners can go back to if they want to hear what I think Palestinian statehood and arguments about it have in common with pointillist and impressionist painting. But anyway, time is always against us.
It is, and we've got to wrap up. So now it falls to me to ask you the famous 3 questions that we ask at the end of every episode. So I can't wait to hear your answer to these 3 questions. And for those who may be listening for the first time, the famous 3 questions are this. First off, what recommendations do you have for anyone who would like to know more about what we've discussed today? Second question, what are you working on at the moment? And third question, what is your current escape route? What are you doing, reading or viewing that takes your mind off international law?
Right. Okay, so in terms of further recommendations, there's a wide literature out there on the South China Sea, but I'll add to the show notes a couple of links on factual questions about what we've been talking about around the Second Thomas Shoal. But also, if you want to understand what the configuration of the shoal is and how very close it is in real terms to the Philippines and how very far away it is from China, just go to the South China Sea Award from 2016 on the Permanent Court of Arbitration website and do a word search. Like, the facts are quite glaring about where it's actually positioned. Also, I'm writing a blog post on the issues we've discussed today with friend of the pod, Rob McLaughlin, been mentioned in dispatches before, and if that's up by the time we go to air, I'll include a link to it. What am I working on at the moment? Well, I'm working on that blog post with Rob. Also working with Alex Green on the treaty recently concluded between Tuvalu and Australia on climate resettlement and continuity of statehood and mutual defence between Tuvalu and Australia, which is terribly interesting. And shortly I should have coming out with Joanna Mossop a piece on dispute resolution under Part 15 of the UN Convention on the Law of the Sea, and whether somewhat controversial cases like the South China Sea Arbitration Award have expanded the dispute settlement system into areas that weren't originally intended, and what does that mean for the future of the UN Convention on the Law of the Sea. So Law of the Sea geeks, watch out for that one in ICLQ, hopefully later this year. Current escape routes, got many. I'll save some for other pods, but something I'm really enjoying doing at the moment, and I've put the odd shot on social media, is I follow a lot of Lego builders on Instagram in terms of just about the geekiest things you could possibly do. And I got inspired by a set that was meant to be a little Japanese street front cafe. And so I tried to replicate it with the Lego collection we've got at home. And I did a reasonable job, but then I realized when I wanted to put a second story on it, I was going to have to start improvising. And the further I got into it, and I was only working from reference photos, the more I had to add my own stuff to it. So I'm now partway through this build without any plans, just kind of making it up as I go along. And it is about the furthest thing from international law I could think of, which is great.
Well, I think we need to see some pictures posted of the final product that you managed to come up with. Spent many hours in the Lego shop in Singapore recently, which was good fun. Well, thank you so much, Douglas. It's been a pleasure to interview you, and we will see you again at some point in the not too distant future.
Juliette, thank you very much for taking the driver's seat on this one, and thank you everyone for listening. We'll be back in a week. Bye-bye.
Bye-bye.